Good morning to everybody and welcome to this webinar, which is organized by the European Lawyers Foundation, the Council of Bars and Law Societies of Europe, and the European Union Intellectual Property Office. It is called Intellectual Property Enforcement: What EU Lawyers Need to Know. This webinar is organized in the framework of an EU project called TRAVAR, which stands for the Training of Lawyers in Various Areas of EU Law, and it's co-funded by the EU. We have a lot of people joining us this morning for this webinar, and so while people are entering, I'll make a number of announcements. My name is Jonathan Goldsmith. I'm Senior Project Counsel at the European Lawyers Foundation, and I will be your moderator this morning. The webinar will be in English, but interpretation is provided in French and Spanish. Please look to the interpretation icon at the bottom of your screen if you want interpretation into French or Spanish, and choose the appropriate language. We very much welcome questions put to the speakers, but please put them in the question and answer box. You'll see another icon at the bottom of your screen. I'm sure you're very used to it from other Zoom webinars. Please put your questions in the question and answer box. We prefer the questions to be put in English if you can, but if not, in French or Spanish, we should be able to cope as well. So we will answer all the questions if time allows at the end of each session or at the end of the webinar if there's time. Please do not use the chat box for questions. We won't answer them from the chat box. We'll answer them in the question and answers. Please use the chat box to present yourselves, say where you're from, or if you need to communicate with other participants. As I say, since many participants are expected, we may not answer all questions. This webinar is being recorded. The recording will be available afterwards in multiple places on the European Lawyers Foundation's website and on the YouTube channels of the EUIPO and of the European Lawyers Foundation, which is at EU Lawyers Foundation. There are two important announcements now before we begin our day. The first thing is that the presentations, you will see our speakers have prepared wonderful slides with a lot of detail on them. They're very useful. These slides, these presentations will be put on the European Lawyers Foundation website. So there's no need for you to ask. I'm telling you now, all the slides will be available on the European Lawyers Foundation website under this particular webinar, which is under the general webinars menu. That's important announcement number one. Important announcement number two is we, the European Lawyers Foundation, do not provide continuing legal education certificates ourselves. If you would like a certificate from your bar because you have a compulsory continuing legal education scheme, please apply to your bar for the certificate. The bar will then write to us and ask whether you participated and for how long. We will give that information and the bar will produce the certificate. As I say, we don't produce the certificate. With all those announcements out of the way, we now begin, and I would like to introduce two speakers who will make brief introductory remarks. The first is the President of the Council of Bars and Law Societies of Europe, the CCBE, Pierre-Dominique Schoup. Pierre-Dominique was President of the Swiss Bar Association from 2013 to 2015 before becoming President of the CCBE at the start of this year. Pierre-Dominique, over to you.
Thank you, Jonathan. This is Mrs. Garces-Cudero. Dear participants, dear colleagues, I'm happy to welcome all speakers and so many participants for this webinar. When I'm saying so many, there have been 1,400 registrations, but due to technical problems, we could only take 1,000, but only this figure shows how big and great the success of this webinar is. As I see so many new faces today and new faces from all over Europe, I was just following all your greetings. People, participants are really from all over Europe. Let me shortly introduce the CCBE and its work. The CCBE, the Council of Bars and Law Societies of Europe, is recognized as the voice of the European legal profession, representing through its members more than 1 million European lawyers. CCBE membership includes the bars and law societies of 46 countries. The defense of the rule of law, human rights, and democratic values are the most important missions of the CCBE. We do represent European bars and law societies in their common interests before European and other international institutions. We regularly act as liaison between its members and the European institution, and international organization, and other legal organizations around the world. Our work is based on expert committees, and I would like to invite you to go on our website to see more information about our concrete activities. The CCBE also fully supports the need to update and develop the professional knowledge and skills of lawyers and other legal professionals on a regular basis in order to ensure and improve the quality of justice across Europe. In this sense, the CCBE considers that the training of justice professionals, including lawyers, about EU law and cross-border issues is essential to ensure the coherent application of EU law and smooth cross-border judicial proceedings, and to build mutual trust in cross-border judicial proceedings, thus helping develop the EU area of justice. In this sense, the CCBE has always, according to its code of conduct, promoted high-quality training for lawyers, as well as a better mutual understanding of different legal systems in Europe. Today's event is the result of a close cooperation with the EUIPO, which was started last year. Indeed, in 2023, it was decided that the two organizations would sign the memorandum of understanding, which has been signed between and outlining the main cooperation areas between our organizations. Today, I'm really pleased to see a result of this cooperation, this webinar, which is organized jointly by the CCBE, the European Lawyers Foundation, and the Observatory of the EUIPO. Just mention the figures of the participants, it shows that this result is really a very good result. As it is foreseen in the program today, you will also see a presentation of the EUIPO brochure for generalist lawyers in the EU with essential information on international property and IP rights enforcement. We are glad that experts of the CCBE were also involved in the work of this brochure, and I hope it will be helpful for all of us. I would also like to thank the European Lawyers Foundation, the ELF, for all support in organizing this event, which takes place in the margin of our TRAVAR project, financially supported by European Commission under its Justice Program. In the framework of the TRAVAR project, several webinars will be organized for lawyers on different topics. The second webinar on international property rights in the framework of the TRAVAR project is planned during the third quarter of 2025. Therefore, do follow the announcements on social media of the CCBE and the ELF, and more detailed information about the second webinar or on intellectual property rights that may be made also on other areas of the law, as well as I just said, at other webinars relevant for lawyers. Dear participants, dear colleague, I would like to wish everyone a very interesting webinar. I hope you will learn a lot. Thank you once again to all co-organizers of this webinar, and in particular to Jonathan Goldsmith and Vasilios Edopoulos, Alenzo Hernandez Pinson of the ELF, and the EUIPO Observatory for their efforts. Thank you very much, and have a very, very fruitful morning. Thank you.
Thank you very much, Pierre-Dominique. Thank you. And we next move on to Patricia Garcia Escudero, who is the director since the start of this year of the European Observatory on Infringements of Intellectual Property Rights, which is part of the EUIPO. She was previously director of the EUIPO's Academy, and before joining EUIPO, she was Director General of the Spanish Patent and Trademark Office, and has also been a Spanish delegate to the Assemblies of the World Intellectual Property Organization, EUIPO, and has lectured at very renowned master's courses on IP in Spain, and promoted the creation of masters and courses on IP and taught around the world. So Patricia, over to you.
Thank you very much, Jonathan. Mr. Schupp, dear participants, it's a very pleasure for me to welcome you on this very first webinar on IP enforcement for generalist lawyers in the EU, organized in collaboration, as Mr. Shub just said, between the EUIPO, the CCBE, and the ELF. It's a pleasure also to say, as he said, that we had a MO signed on 2023, and we will envisage a lot of activities under the framework of this MOU. It's a great opportunity for me, as Jonathan said. I'm really new in the observatory. I joined it on the 1st of January, but I may be new, but I highly value the importance of promoting the protection of IP rights against infringement since my time as director of the Spanish Patent and Trademark Office. So I consider any initiative in this regard as instrumental. I therefore look forward to working together with all of you. Since 2012, when the EU legislature entrusted the European Observatory on infringements of intellectual property rights to the EUIPO, one of its objectives has been to enhance the expertise of persons involved in the enforcement of IP rights. This includes IP professionals, judges, prosecutors, private sector companies, as well as police and custom officials. As a knowledge hub on IP enforcement, the observatory also gathers, monitors, and reports crucial information to assist all stakeholders engaged in protecting and enforcing IP rights. One of the observatory flagship studies, the SME Scoreboard, has since 2016 explored the relationship between SMEs and IPRs. The latest data show that 15% of SMEs that own IPRs in the EU have experienced IPR infringements, and many of those lack the knowledge needed to enforce their rights. The SME Scoreboard also highlighted that one of the first sources of information that small companies turn to when it comes to IP is to their lawyer. Therefore, we teamed up with the CCBE with the primary objective of providing an enhanced support to you, the lawyers in Europe, who in turn will help your clients, including smaller businesses, in IPR-related pre-litigation situations. As part of the implementation of the MOU undersigned with CCBE, we developed together a concise brochure published in all EU languages ahead of this seminar. I really encourage you to have a look at it because it's very practical and I think it would be very useful. This aims to help you provide your clients, in particular SMEs, with initial advice in IP rights related pre-litigation situation and as well as possible next steps. We understand that you might not deal with IP matters on a daily basis, but we truly believe that this document will be useful to you when clients approach with IP enforcement-related cases. The brochure contains, among other, information on why IPI protection and enforcement are important for businesses and an overview of the relevant types of IP and how it can be protected. It also includes practical real-life scenarios in which your client could find themselves, both as a claimant and as a defendant, and potential initial solutions to those. Today's training and the brochure are contributing to the numerous already existing EUIPO initiatives in support on SMEs enforce their IP rights, such as the IP Enforcement Portal or the Anti-Counterfeiting Technology Guide, and the IP Scan Enforcement Service. From my previous experience as director of the Academy of EUIPO, I'm deeply convinced that lifelong learning plays a central role in supporting the IP ecosystem. Indeed, training and knowledge sharing is also a central part of the observatory's role in supporting IP enforcement. I trust that webinars like this will help facilitate the day-to-day work of lawyers in the EU that work with smaller businesses. I'm really happy to see that there has been more than 1,400 registrations. We are now 605, and we have just begun the session. And from all over Europe and beyond, we've got non-EU countries such Ukraine, Georgia, Moldova, Turkey, United Kingdom, Brazil, India, Mexico, Switzerland, South Africa, etc. Lastly, I would like to thank the teams in charge of the organization, and I'm very grateful for our excellent partnership with the CCBE and the ELF, and look forward to continuing our fruitful collaboration in the future. Thank you for your attention and wish you an insightful and productive training session, and encourage you to be active and engaged. My team and I remain at your disposal. Thank you.
Thank you very much, Patricia. Thank you indeed. Whilst you were talking, there was a question about a link to the brochure you mentioned. A link has been put in the chat whilst you were speaking. So that's just to answer that question. Yes, indeed. Thank you very much. Let's move on so we stick to time, and let's begin now on the first substantive session of the morning, which is why IP and IP enforcement are important for your client. And our speaker will be Plamen Ivanov, who comes from the Observatory of the EUIPO. He's a Bulgarian lawyer and a former attorney at law with 25 years of experience in IP matters. He joined the EUIPO in 2012 and was working for 8 years in the core business of drafting oppositions and cancellation decisions and representing the office before the General Court and the Court of Justice of the EU. In 2020, he started working in the IP service and the digital world of the Observatory. So, Plamen, over to you, please.
Thank you very much, Jonathan. I hope that you can hear me and that you can see the first slide of my presentation. If this is the case, please confirm.
Yes, both are true. Carry on.
Good. Thank you very much, and good morning, everyone. I'm really happy to be back among colleagues from the private practice. I was entrusted with the task of making a general overview of the importance of intellectual property, as well as to share with you the basics of intellectual property law. The objective of this introductory presentation is to set the scene for my colleagues, who will then deep dive into the complexities of selected IP law issues. I will now start with the value of intellectual property. One of the main ways to understand why IP is important is, of course, have a look at some numbers. And I decided to start with this graphic on the right of your screens that shows how the economy changed in the last 50 years. And more specifically, what was the percentage of tangible versus intangible assets in the capital of the 500 biggest companies in the world. Nowadays, more than 90%, as you can see, of the assets that the companies have in their balance sheets are intangible. Intangible are the assets that are the result of the human creativity and innovation. And we refer to those results as intellectual property. On the left, I listed some of the most common examples. You know probably that a patent protects an invention, and it may seem obvious, but every now and then, even from colleague lawyers, I hear things like, you know, I read an article that says that Taylor Swift got a patent for her name. Well, no, she cannot get a patent on her name, because patents protect technical innovations, new technical solutions to an existing problem. Then you have, of course, the trademarks as another type of IP right, which is basically a business identifier that distinguishes your products from the products of your competitors. Copyright obviously protects artistic and literary works, and software is also protected by copyright, at least here in the European Union or in Europe. And then another good example of an intellectual property right would be the design that protects the appearance of a product that attracts the attention of the clients. There are also other types of IP rights, such as geographical indications, plant varieties, utility models in certain jurisdictions, integrated circuits, and even trade secrets are considered type of IP right in certain jurisdictions. Now, just think about some of the most expensive companies in the world, like Google, Amazon, Microsoft. These are businesses that are mainly based on intellectual property assets. Or take, for instance, Uber, $1 billion business that basically consists of a software application and a trademark. It may seem like a transportation service, but it could well be that they themselves don't own even a single car. Now, moving further to the importance of IP and some more data, the European Union Intellectual Properties, and in particular the Observatory, in cooperation with other IP institutions like the European Patent Office, is producing a number of studies which give us a quantitative idea about the importance of intellectual property and its value. Now, some of the main findings of these studies that you can see on the right of your screens are that 47% of the total economic activity in the EU is attributable to IPR-intensive industries, which are worth 6.4 trillion euros. Now, I'm not going to get into the definitions of what IPR-intensive industries are, but you can imagine that these are industries that are using a lot of IP assets in their business, in their work. Furthermore, 39.4% of all the employment in the EU, or 81 million people, are engaged in those industries to the IPR-intensive industries. These studies also established a strong positive relationship between the ownership of IP rights and the firm performance in terms of revenue and wages. The companies that are using more IP rights in their business, they get higher revenues, and the wages, the salaries of their employees are higher. And finally, since SMEs were mentioned as a focus of our work here, these studies established also a positive association for SMEs. There is a bit of an issue with the SMEs who lack knowledge about IPRs. They have the perception of the registration procedures as complex and costly. So in this area, we see the role also of lawyers, generalists. Now, I would like to say a few words about how IP actually boosts creativity and innovation. And while this may seem obvious, I still think it is worthwhile to point out that innovation does not occur spontaneously. It requires conscious effort on the part of some creative individual or group of individuals willing to dedicate time, effort, and resources to produce something new. Or to put it simply, it is the innovator's work which yields the innovation. That's why IP provides a framework in which creators and innovators can receive recognition and rewards for their intellectual efforts. So IP protects the investments, the time, the money that the creators and inventors are actually investing in the result of their intellectual work. This in turn incentivizes further innovation and creativity, benefiting not just the creators, not just the individuals, the inventors, but also the society as a whole. And as we saw in the previous slides, the creation and the innovation are actually driving the economic growth. Now, going to some basic legal principles, I would just briefly outline them without going into too much details. This is something that my colleagues will do later on. but you may already know or might be interested to know that these are monopoly rights. You know that monopolies are generally bad for the market economy. However, the legislator decided to give them protection because of the considerations that I mentioned in the previous slide. Nevertheless, most of them are limited in time. Patents for 20 years, designs for up to 25 years, copyright 70 years after the death of the author, etc., etc. Now, IP rights are also exclusive rights, meaning that their owners are the ones who can exploit them commercially and prevent others from doing so. So without the consent of the owner, nobody can use these rights or assets in any possible way. And this gives the owners a competitive advantage on the market, which generates revenues in different ways, which we will see in a couple of minutes. Now, you have to bear in mind also that for all the IP rights, the principle of territoriality applies, which means that if you have the right to your trademark in a certain jurisdiction, let's say in Poland, then this protection is limited also with only within the borders of Poland. There are certain exceptions to this rule. You may think about the Benelux office that grants protection with one registration for 3 countries, and of course the European Union, where you can register a single trademark that will be valid for the entire union or a community design. It is not exactly the same with the European patents, because there you don't get a unitary patent, not until long ago. Now, recently we have this system also in place. But what happens at the European Patent Office is that you get a bundle of national rights and not a single right. And then we have the World Intellectual Property Organization that offers the so-called international registration, which is again just a system that facilitates the registration, but does not give you a unitary right somewhere in the world. Then what is also typical for IP rights is that most of them are registered, but there are also unregistered rights, and as other registered rights, here the priority matters and plays a substantial role. And for those of you that are dealing with real estate, in order to make a parallel, IP rights can be subject to rights in rem, which means that you can pledge a trademark and you can use it as a security for a debt, or you can get money for it. I will continue with what I just mentioned, with some information about how you can actually monetize your IP rights. And I provided some examples next to the different forms of monetizing IP. The trademark that you can see on the upper left corner is currently offered for sale for $23 million. Just the trademark, without any underlying business. So you can imagine, and you should be aware that those assets can be sold, transferred, regardless of the undertaking. Then the opposite can also happen. You can buy the undertaking where the trademark plays a significant role and gives a significant value to the business, but then you decide to change it just because you are an eccentric billionaire. And then you can license your trademarks. I gave an example of a Gibson mandolin. Some of you may know, some others not, that before he started designing his famous guitars, he got a patent on a flatback mandolin, and it was licensed later on to 4 individuals that started mass production of these musical instruments. And then you see a car that was manufactured in Bulgaria under the license of Renault in the 60s. And then you see some examples of famous franchise businesses like Subway. And if there are Finnish colleagues among you, you would know probably the trademark Arnold's as well. Co-branding is also a way of monetizing IP. And then you have less popular but still existing ways of monetizing IP, like crowdfunding, IP-backed financing, and R&D grants.
Plamen, before you go any further, because we're 5 minutes from the end, there are a couple of questions, and I think it's important to take them to encourage people to put questions. They may not be for you, and so if they're not for you, your colleagues will follow them up later. The first is from Elmira Liapina, and she's really asking about what is happening now in general because of the current political situation with Russia, EU-Russian relationships, the sanctions, Russian sanctions, many EU companies leaving from Russia, and about IP infringement from the Russian side of EU brands, and what enforcement measures can be implemented. I don't know whether you can comment on that.
Well, I would refrain from commenting on political issues. To be honest, yes, we do have a problem, but as lawyers, I would prefer to comment on a particular case, because we see different things happening in Russia. In some cases, whole businesses are taken over by the state. In some cases, there might be some compensation for their IP rights. In some others, no. What the EUIPO is doing is that we stopped any cooperation with the Russian Patent Office. It was existing before the war. Now we do not cooperate on any programs with the Russian Patent Office. So I would limit myself with this answer to this question.
Thank you. That's absolutely fine. We then have a question from Luc Commence, which enables me to make a general point, which is that none of our speakers today can give legal advice on specific cases. That's not what they're there for. But from Luc's question, there is a point of principle, a general question, which is whether somebody who is, if the holder of the intellectual property doesn't want to take any action for a breach, is somebody else entitled to make a complaint based on the intellectual property for which that person is not the holder?
Yes, there are different situations in this regard. You may be a third party that is concerned by an IP infringement case. You can be the distributor, or you can be a licensee, something that has to be agreed in a license agreement, whether the licensee will have the rights to step in a case of an infringement case and represent the interests of the IP owner. There again, various constellations, but in general, yes, there are situations in which a third party, whether according to a contractual relationship or according to a statutory provision in the respective legislation, can step in and protect the IP owner's rights.
Very good. And I see another question has just come back. No, nothing. That's a logistical question. Fine. You have a couple of minutes, Plamen, if you just want to wind up your slides before we move up to the next one. Thank you for answering the question.
Happy to answer to a few more questions, but if there are not any, I will just take the 1 or 2 minutes left to finish my presentation. I literally have 2 more slides.
Thank you.
So the one that I am already displaying on your screens just shows again the results of some other studies that the European Observatory on Infringements of IP Rights did. Well, the main findings are that in 2013, but until today, the international trade in counterfeit represents a significant portion of the entire world trade. And this is just to give you some idea again about the importance of fighting IP crime. We are here talking basically about counterfeiting and piracy. And you can see as well that for the EU, these products amount to 5% of all EU imports, worth of up to 85 billion euros. And counterfeit and pirated goods can be found in virtually all the sectors of the economy, from smartphones through wines and spirits to toys and cosmetics. So these numbers speak for themselves, and there is no need to convince you that you, in particular, the colleagues that are dealing with enforcement on a daily basis, how important the enforcement of IP rights is. And if we are at the end of my time slot, I would not go into the details of this final slide. This is the last that I have, but I'm not going to go into these details because my colleagues later on will discuss these issues in details. So I thank you very much for the attention. If you don't have any other questions, I will just.
There's one more question, but I
Okay,
think
happy to take it.
Okay, I think I was going to say we should move on, but another colleague can answer it. It says you mentioned the licensee can sue for trademark infringement. Is it necessary to have the license recorded in order for the licensee to sue for trademark infringement, or is it sufficient to have a license agreement in writing, even if not recorded? If you could be very brief, then please, Plamen.
Yeah, well, again, this would depend on the national law. If you are referring to a license of a European trademark, then this is not necessary. It does not have this constitutive effect. But then if you are talking about a national right, I would refrain from giving you a general answer because the provisions are, of course, different depending on the national legislation.
Thank you, Plamen. Thank you very much indeed. And we encourage you to say more questions. But let's move on to our next speaker. The next speaker is Erling Vestergaard, who will speak about types of IP rights and their protection from an enforcement perspective. Erling has been a Danish lawyer for 35 years. He comes from the observatory at the EUIPO. 21 of these 35 years was serving as a Danish prosecutor. He has since 2006 specialized in intellectual property and internet-related issues, and from November 2014, he's been working for the EUIPO. Please, Erling, over to you.
Thanks a lot, Jonathan. Thanks for the introduction, and thank you for giving me the chance to address this very interesting webinar. Yes, I did serve as a prosecutor for 21 years. However, I will only on a single slide have a very few it be related to civil problems and issues around protection and enforcement. And wow, thanks a lot, Plum. It's going to be really, really easy for me to follow up on what you introduced, and I'll try to take bits and pieces from your presentation and elaborate a little bit.
By the way, Erling, your slides are not up on the screen.
They should be.
They started to come, but then they went off again.
Then they went up again. Then we try again. Did it help now?
Yeah.
Ah, that's perfect.
Thank you. Thank you.
Thanks a lot. Exactly as Plamen said, intellectual property and intellectual property rights are part of property, and it has most of the same characteristics as other types of property, whether it is real property, movable property, that we all of us to different extents are owners of. And as also indicated by Plamen, what characterizes intellectual property rights is that some of them are based on registration procedures. Some of them they exist just by their creation and do not require a registration. And then outside of the intellectual property rights, we have a number of non-exclusive rights to certain actions. That is also very important, and one of those really, really important areas are the areas of trade secrets. But we also have elements of competition law and unfair competition practices, and I'll mention how that integrates with the intellectual property rights. Now, the main difference between the real property and the movable property and the intellectual property is, of course, that the intellectual property is intangible. And we, of course, have seen with the rise of the online environment, there's lots of other new types of property that's also intangible. It's becoming more and more important in our lives. And I'm just mentioning IP addresses on the internet, domain names that is so closely connected to intellectual property, and the rise of virtual currencies and the ability for us to own property by way of non-fungible tokens. It just shows us that actually the concept of having a property right based on something that is intangible is becoming more and more important. Usually, intellectual property rights are in the area of science and technology, market and competition, and arts and culture. Trademark, geographical indications, designs, patents, known as industrial rights, and we have the whole area of protection of creativity and performances that falls under copyright protection. Now, I come from Denmark, and I have two slides that relates to the country where I come from, and anybody who have visited Copenhagen will have passed by the Little Mermaid. And I think the two examples here are very illustrative of one of the points that was made by Pierre Dominique and the interaction between intellectual property rights and other pieces of law. And that is the concept that intellectual property, like other pieces of property, are protected by fundamental rights. And it is now enshrined directly in the Charter of Fundamental Rights of the European Union that intellectual property shall be protected in the same way as other types of property. But it also means that intellectual property rights will be limited by fundamental rights. And in this case, that was resolved by the Danish Supreme Court. And I have you can click the link later on when you have the slides. There was the question whether the use of this protected work in the way that it was done here for participating in public debate around corona restrictions, how that would play out. And the Supreme Court recognized that the use of the copyright protected work of the Little Mermaid as a parody were protected by the freedom of expression in the example to the right, and in the example to the left. The Supreme Court also recognized that it was the right of the newspaper that had used this drawing of a zombie Little Mermaid, that was a part of the public debate around corona restrictions. So while intellectual property is protected as other pieces of property by fundamental rights, they can also be affected by the fundamental rights in the sense that the extent and scope of the protection is then limited. Intellectual property is generally always founded in law. Of course, we have certain legislative systems where we have common law principles. And generally, intellectual property always have a time limit. Some intellectual properties can then be extended almost indefinitely. That's another issue, but we always have to be aware of the length of protection. And as Plamen discussed, they are negotiable and assignable, and they can be licensed, and they can be inherited, and so on. One of the most important international principles is very strict principles of non-discrimination. So basically, if a country is a member of the World Trade Organization, which almost all countries are, we have to treat, for protection and enforcement purposes, proprietors of intellectual property in the same way, no matter from where and what country that is a member of the WTO that they come from. It's a very, very important principle, and it has been expressed in the principle of national treatment and the principle of most favored country principles. Intellectual property are in principle always territorial in scope. Of course, that doesn't mean that you could have a company that has exactly the same trademark protected in almost all countries of the world, but you will still have to look at the territory specifically to determine the precise scope and extent of that protection. I will only talk about 3 rights here. We could talk for weeks about all different rights, but I think for this webinar, copyright, design rights, and trademarks have a very high level of relevance, and they overlap each other a lot. Copyright, original works that express an author's own intellectual protection, where there is generally not a registration requirement for protection, and a very long duration of the protection, actually 70 years after the death of the creator of the work. Design rights overlapping a lot with copyright, but protecting the external appearance of a product. They are usually registered, but there is in the EU a short 3-year protection of unregistered designs as well. Designs have a shorter maximum length of protection, as it can only go up to 25 years. Trademarks are different from that because they can be extended every 10 years. So if the requirements are still met, they can be continued for a longer period of time. They are business identifiers, as said by Plamen, distinctive identification of the source of goods and services, mostly registered, but some countries also have protection of unregistered designs. And as I said, closely linked to intellectual property, we have trade secret, domain names, different passing off and unfair competition rules, and registration of company names outside of the area of trademarks. A product can be protected by many different intellectual properties at the same time. And just take this mobile phone, the smartphone. It will have a brand name, probably a product line name. It can even be the startup tone protected by trademarks. Lots of copyright here, just from the software in the device, the user manuals, ringtones, startup tones, images and video, advertising, design, shape of the phone, arrangements of buttons, position and shape of the screen. There'll be thousands of patents in a mobile device like this one. Data processing methods, operating system, user interface integration, encryption systems, and lots of other things that is protected. And then there'll be trade secrets. The producer of the phone will, in their development of the phone, holds a vast amount of trade secrets. That's really, really important for them to maintain their market share. And that can be, as I mentioned, unfair competition rules that plays into that as well. Even a sport, and here I'm imagining a soccer player, even a sport can be protected by multiple intellectual property. There are trademarks for leaguers and clubs, and player names very often protected by trademarks when marketing different kinds of clothing and apparels, sponsor brands. We have designs of clothing and other items as well, and a lot of copyright in sport. Logos, music that is connected to, for instance, a sports broadcast. There can be databases, video game adaptations, and we have something called related rights, which has to do with the performances itself, and we have a related right very often protected in different countries as for television broadcasts. So the signal itself of the television broadcast. Sports events in themselves are rarely protected by copyright, but there will be so much around the sports event that will be copyright protected. And of course, we have use of domain names, and the ownership of the stadium provides certain rights, and that is the basis of the licensing of the broadcast. That happens in the different sports events. And even trade secrets, like the strategy for a specific game that one of the teams is going to engage in a very short time, can be protected by trade secret. So, and my whole point with those two slides is think big when you deal with protection and enforcement. Don't forget something, because actually when the claim is being brought before court, it's a good thing to think to claim as much protection as is possible, not to rely on just a single IP, but as rely in court on as many as possible. Plamen was talked about the exclusivity in IP, a metaphor that the former president of the Danish Maritime and Commercial Court taught me was, IP are islands of exclusivity in an ocean of free trade. And I think it's a good metaphor, because this public contract around creation of IP and this exclusivity, it always has to be balanced, that we want free trade at the same time. So exclusivity should be given to the extent that it's necessary for that public contract that exists in society that legitimizes IP. But at the same time, we need free trade. A British judge used in a patent case a metaphor for IP protection, and he said in this case, when the right holder applies for an intellectual property right for registration, he's like an Angora cat. He takes the hairs and folds them nicely around the body of the cat. But when he wants to enforce it, he pulls water on the cat and takes a blow dryer, and all the hairs are standing out. So very often, we will not know the full extent of the protection until the case is heard in court. And it will very often be that the extended claim of protection will then be determined by the court, that actually it is only what was precisely registered that is actually protected. And I think that's my third important point of today, really to emphasize that when we have registered rights and we go to court, it is up to the courts to enforce only what was actually registered and not necessarily what is claimed by the right holder in the case, because what you see is what you get. Having a few observations about copyright will hopefully show you that copyright is a quite broad concept. Here I have a birthday train, a cosmetics box, a winter boot, a flashlight, a water bottle, a rowing machine, a hanging flower pot, and the Batmobile, and a Starship Trooper helmet from the Starship, from the Star Wars movie series. And my rhetorical question to you is, which of these items are copyright protected? Which of these items are original works? I'll reply to the question in just a second. I said, when we deal with copyright, we're in the artistic field. And in the case about the Starship Trooper helmet, the judge said, and I think that really explains what copyright is, a pile of bricks temporarily on display at the Tate Modern for 2 weeks is plainly capable of being a sculpture. The identical pile of bricks dumped at the end of my driveway for 2 weeks, preparatory to a building project, is equally not. One asks, why is there a difference? And the answer lies, in my view, in having regards to its purpose. One is created by the hand of an artist for artistic purposes, and the other is created by a builder for building purposes. We have not full harmonization of copyright in Europe, but the Court of Justice has, in extensive and growing number of cases, defined what is the scope of protection and basically created a uniform criteria for what is protected by copyright, basically anything that is original in the sense that it expresses the author's own individual creation. And that leads me to reply to the question. All of these items have in one or more civil court case been recognized as having been original copyright protected works. All of them. I'll mention the hanging flower pot in my last slide. Except the Starship Trooper helmet, which was not protected. It would have been protected, I think, in almost all countries of the world, but in that specific court case, there was a specificity in UK copyright law that then meant that that was not considered to be copyright protected. It would have been protected, I think, most other places. So the flashlight, the water bottle, the rowing machine, the birthday train, and the cosmetics box and the winter boots have been recognized as having been original artistic works protected by copyright. Design rights are very close to copyright, and I'll mention you the most important design court case ever. It was ruled by the same judge, actually, that I quoted before with the Angora cat. The case is about a UK company, Magmatic, that had EU registration for children's suitcases. We all know these children's suitcases when we come to the airport. There was a Hong Kong company that noticed that this was an interesting design, and there was no discount versions available of these children's suitcases. So they produced the Kitty, a competing product. They were clearly inspired by the Magmatic Trunky design, but there was also differences. Kitty comes on the market, and Magmatic, producing the Trunky suitcase, they sue the Hong Kong company for design infringement in the UK. The registered design looked like this, a grayscale picture, an animal shape. The handles of the suitcase were two horns in the front, and the tail was a round name tag. There were four wheels, a strap, and two lines on the front, and the rear were in black. You can see here these specificities. Animal shape with horns, grayscale, four wheels, a strap, two lines on the front, and the rear were in black. All kinds of angles were included in the design application and the design registration. Now, if we look at two examples of product, we have the Trunky product here, and we have the new competing, cheaper Kitty product to the right. There were several examples of this. The first instance court ruling, and one of the reasons why I like this case, and there are many, many good reasons for that, but it's always interesting to see when different court instances reaches different conclusions in a case, because then we can really understand what are the specificities about intellectual property protection, now in this case specifically design. But there are some thoughts and principles applied by the courts here in this case that goes way beyond the principles of design protection. Now, the first instance court finds in favor of the plaintiff, Magmatic, that had produced the Trunky case. The registered design was evidently for the shape of the suitcase. When comparing the registered design with the Kitty case, the graphical designs on the surface of the Kitty case are to be ignored, the court says. Infringement based on comparison of the respective designs with the registered design, and the first instance court finds that the Kitty product infringes upon the registered design of the Trunky case. This goes to the appeal court, and the appeal court overturns the High Court ruling and finds no infringement. The Court of Appeal sees that there are differences in the overall impression of a horned animal and various insects. So the Trunky case represents a horned animal But what is on the kitty is an insect. The registered design was in gray and black only and had no decorations. The color and contrast had significant differences, and the wheels on the kitty were covered, unlike the registered design, which is very clearly when you look at the picture here of the kitty product. So the Court of Appeal takes a fundamentally different stance to the concrete question about whether there was an infringement of the Trunki registered design by way of these kitty products. It goes to the Supreme Court, and the Supreme Court upholds the appeal court ruling. An applicant for a design is entitled with very broad limits to submit any images they choose. By submitting grayscale photos of the design, in the specific case, they limited their scope of protection to what was visible on those photos of the designs. And the court quotes an old patent court case from the 1970s that basically said, it is not up to the court of law to improve upon a registered right. Society puts forward the ability of companies and individuals to get an exclusive right to certain acts by way of registration. In this case, a design registration. But the choices of the right holder making the application, if they made a mistake, if they should have done it differently, if they should have had more variations protected, that is not up to the courts to remedy that decision later on. And then we are back to the Angora cat, because what you see is what you get. If that was what you applied for, and that was accepted by the registration office, then that is the protection that you will get. That is the rule of thumb. So we have to be really, really put attention to what was it that was applied for, what was it that was protected. And the courts will generally not improve upon an application at a later stage. And that's very clearly illustrated by the court case from the 1970s. That was a patent case, and this case about the design that went to the UK Supreme Court. It is for an applicant to make clear what is included and what is excluded. And then, if we have a look here, I think we must agree with the Appeal Court and the Supreme Court of the UK that there are the overall impression of what is registered in the Trunki design registration and the competing product that we put on the market are very significant. And that takes me to the last right, the trademarks. Like design rights considered to be one of the industrial rights, and trademarks being these commercial or these distinctive identifiers for commercial activities, whether in the area of production and marketing of physical goods, or whether we are talking about services. Usually registered and with potentially very long and very strong length of protection, as it usually is able to, it's usually possible to extend the protection of a trademark every 10 years in a renewal application. Basically, a trademark consists of two elements. There has to be a mark that is suitable to distinguish goods and services, and we call that distinctiveness. Distinctiveness can be inherent, it can be from the beginning, or it can be acquired over time by the use of the mark. And then in the registration, there'll be a list of goods and services that is protected by that specific mark, and that's the specialty. I made a little checklist just for myself, not to forget something important when we are talking about protection. and enforcement of trademarks. But first of all, I said trademark rights are industrial rights, and that means they only protect actions or acts in the course of trade. It has to have a commercial element. So the use of a mark in purely private setting, which is different from copyright, that sometimes has an effect even in the privacy of our own homes. But for trademarks, we only consider the protection and infringement if we are having to do with acts in the course of trade. And the Court of Justice, again, lots of court decisions in trademark field. Generally, intellectual property is one of the areas where we have a lot of court decisions, both from the Court of Justice of the European Union, from national courts. But the Court of Justice have guided us a lot to understand the nature of the trademark rights. And here they said that in the act in the course of trade is if something is used in the course of a commercial activity with a view to gain and not as a private matter, beautifully expressed here by the Court of Justice in the Celine case. What could trademark use be? What could be examples of such commercial acts? Well, if you put the mark on a product or packaging of it, if you put the product up for sale, put them on the market, and even storing the goods with the aim of putting them on the market. Import, export, even to some extent goods in transit can be protected. There are some limitations to that as well. The use on business papers or in advertising, in illegal comparative advertising, and labels and packaging with the use of the mark. These could be very practical examples of what would fall under the protection of trademarks and what could be infringing acts in regards to these trademarks. Now, Plamen said it very clearly, well, if the use of the mark has happened with the consent of the right holder, there is no infringement. And that can happen through a licensing agreement. It can happen through many other forms. But if to have an infringement, we need that the act did not happen with the consent of the right holder. It has to be in the relevant territory. I said that trademarks are territorial. In the EU, we have two fundamental different trademarks. We have the ones that have been registered in EUIPO, from where I'm speaking right now, and they have a direct protection in all of the 27 EU member states. But there is also the possibility of a national registration or a national unregistered right if it is recognized in that country. And then it will only be for that territory that protection is. But for an EU trademark, it will extend to all of the EU member states at the same time. So we always have to be aware what territory are we in. And of course, when we are online, this becomes really, really important because where does the commercial activity originate from? Where does it have effect? Which markets are targeted by the commercial activity? All these things we have to consider, but we always have to think what is the territory of that protection. And it has to affect the trademark function, and the main function is to separate goods and services from one commercial undertaking from those from another commercial undertaking. But when we came to the online environment, especially, the Court of Justice have also taught us there are some derived functions. This can be very, very important to be aware of. For instance, it can make the case more aggravated if more trademark functions are affected in the same case at the same time. There is a quality guarantee in a trademark. That means a product was produced under the control of a single commercial entity that guarantees the quality of that product, who is responsible for that product. And if somebody infringes by a counterfeit low quality product, it affects the quality guarantee of the legitimate product. There's a communications effect in trademarks, especially online with social media and so on. Trademarks communicate between the company and the and the consumers. There's an investment function in trademarks. Enormous amounts of value is invested in trademarks, and there's an advertising function. Be very aware of these derived functions from the main trademark function of the separation function. It has to be within the scope of protection, and basically in Europe we operate with 4 areas of trademark protection. We have the double identity protection, identical mark used for identical goods and services as is in the registration, gives us a very strong absolute protection. And then we have identical marks for similar goods and services if there is a likelihood of confusion for the consumers, or similar marks for identical goods and services as is in the registration if there is a likelihood of confusion. And then we are giving an extended protection to trademarks with a reputation, even for dissimilar goods and services. But it requires that the earlier trademark has a reputation in the market, and that the infringing mark, the contested mark, takes unfair commercial advantage of the reputed nature of that mark, or is detrimental to the character and reputation of the trademark. This is very, very important, and certainly for cases I have ever been involved with, very often that would be an element of taking into consideration if this mark had a reputation in the market or not. So these are the 4 areas that defines the scope of protection for trademarks. This is a fully harmonized criteria, so it will be the same for the EU trademark as for nationally registered trademarks. Now, I don't know if you associate, I hope I created an association here with you looking at the slide here, because my idea was that you should associate this with the Arsenal Soccer Club. The Arsenal ruling was a very, very important court ruling, one of the most important rulings in trademark law in Europe. It came from the Court of Justice already in 2001. It was also a referral from the United Kingdom at the time. Basically, what had happened was a fan of Arsenal Football Club had made a stall outside of the football stadium, and he was selling counterfeit versions of items with bearing the Arsenal trademark and logos and brand. And he had put a sign on top of the stall that said, "These are not original Arsenal items." So nobody was deceived. A consumer that went to the store, bought a t-shirt that looked exactly like an original Arsenal t-shirt, would not be confused, he would not be deceived in any way. So it was argued from his side, but I didn't infringe anything on Arsenal, because, well, what you see is what you get, and I told everybody that they weren't originals. But the Court of Justice said, no, that is not true. We can still have confusion in the marketplace, because when the t-shirts are worn by people outside the area where the product was being sold, it would still signal a commercial connection to Arsenal. So the Court of Justice told us it's not a requirement for trademark infringement that the consumers are deceived. This is a super interesting question also for criminal law protection of trademarks, because certain countries have some limitations for that. But this is a very important ruling from the Court of Justice, and it's a very important principle.
Erling, I'm going to stop you there because really we have quite a lot of very interesting questions, and so there are about 6 minutes left, and so I'll try and get through them very quickly. We have 2 which are on territoriality, which you mentioned. One, which is presumably from Greece, says that the person has faced many times a rather hostile attitude from Greek civil courts, considering that since a certain company is established on the territory of a different member state, and despite them being a holder of an EU trademark, there's no risk of confusion with a national company using a similar trademark, which is very tough, this person says. And then there's another question on from Elmira Liapina, who says, regarding territoriality, Can you provide examples of cases, if you remember any, on the application of EU protection and enforcement in cross-border infringements? Maybe you could just spend a minute talking about that, because we have quite a few other questions. Thank you.
Yeah, thanks a lot for that question. And that actually goes very, very nicely to the enforcement measures here. So I'll actually reply to him by showing you the next slide. Well, to enforce IP, we have different tools available: civil enforcement, border measures, criminal enforcement, and administrative enforcement. And the civil measures are harmonized to a very high level in regard to the EU and implemented into national law. So if you have this case in a specific country and you have an EU trademark, and the EU trademark is protected in all of the countries, you can come with this claim from the right holder. Will be able, by using these civil enforcement tools, to gather information and evidences from the defendant and from third parties, and they can go to court with claims for injunctions, even against third parties, and they can come with claims for damages. But in this case, the fact that you have a uniform protection all over the EU doesn't mean that you necessarily have an infringement in all the different countries. And you could very well have a situation where in one of the EU member states, there is not an infringement, and even the very, very same case, the same EU trademark, the same contested product that was put on the market, creates confusion in another country, and that will rely on a lot of factual elements of that case. So in principle, yes, you can have a situation where even if you have the uniformly protected trademark all over Europe, the scope of protection will not be exactly the same. That can, for instance, be due to the market structure or due to language factors in the different countries. So I'm very sorry to hear the word hostile being used here, but definitely there can be a difference. What could be an example? Well, we had a civil enforcement case that was built on a border measure, and that was a situation where there had been a vendor in China that was selling counterfeit Rolex watches from China, and a consumer in Europe bought one of those Rolex watches. It was intercepted by the customs authorities on the border, and the Court of Justice had to determine, was this a violation of copyright protected in the original work of the Rolex watch and the trademark of the Rolex watch? And there the Court of Justice said yes, but they were marketing the things from the website in China, and when they were shipping the goods, it was one long consecutive line of delivery until it was received by the consumer in Europe, and therefore it was an infringement of the territoriality of Europe that there had been this marketing from China and delivery, actual deliveries into Europe of the watches, and the customs authorities could intercept the package. But even the act from a website, for instance, outside of Europe, that is marketing a good protected by a copyright or a trademark, even if there wasn't an actual delivery, it will still be an infringing act, because that activity was targeting the European territory where that copyright or trademark would be protected. So I got the chance to reply to the question and actually doing my slides there, Jonathan. Yeah.
Okay. Okay. Time. Next question. Can rules of a game be protected by copyright? Does that apply to sports games as well? For example, can you protect rules of judo and the level of belts and all this sort of thing?
I think the general question will probably be a no, because what we protect are not concepts but expressions of concept. But if I am making a new board game where two fighting monster armies in space are fighting each other, definitely there will be a lot of elements in that board game, the instruction manual, the design of the playing, the board, the design of the small figures that moves on the board, as will be in if it was a video game, can be protected. But just the concept that two warring armies are fighting each other in accordance with a number of rules, that will not be protected as such. That will be protected we will call that the concept, but the expression of the concept could be to some extent protected. But the rules of judo fighting or karate, no, that would not fall under copyright protection.
Thank you, thank you. This came when you were talking about deception and arsenal, and also before that when you were talking about Trunky and Kiddie. And the question is bad faith not taken into consideration? In other words, the intention, I presume, of the person who is, yeah, go on.
It's a very good question, and that I can actually reply that with my last case example here. This is a copyright case. It was a Danish designer called Anne Black that had created these. The flower pot is protected by copyright, the court said, and the other two were protected by unfair competition rules. And in this case, it was very clear that the infringing party had acted with a very severe high level of bad faith. And the court, the Supreme Court, took that into consideration and said, by the gravity of the bad faith, affected the level of the burden of proof on how big the loss was. So absolutely, that factor can play an essential role in both the infringement determination, but also in the sanctions that are being put in place as a result of the infringement action. And some parts of the trademark law, the concept of bad faith is very, very important. So yes, it is part of the facts that needs to be established to the widest extent possible in a civil proceeding.
I'm so pleased these questions are tying into your slides. A next question from Maria Ankel. She says, when you refer to commercial activity or acts in the course of trade, do you exclude NGOs, by which I assume she means non-profits?
No, I do not, because an NGO will also be engaging in a commercial activity. You can pay your membership. They also sell T-shirts. They also do acts that will be considered, could fall under commercial act. So absolutely not. What I mean by it could be in the privacy of my own home, for instance, would be using a mark of a registered trademark. That would fall outside the scope of protection. But a lot of NGO work falls under the scope of in the acts of trade.
Thank you. Next question. As you see, I told you there were lots of questions from Flavia Suare, who, and maybe this is for a subsequent speaker, but you will say, can you protect your voice and personality from an AI remix so that the AI has to indicate who is being copied here?
This question about personality protection is super interesting. And actually, in the case that inspired me to the soccer player, was an actual case about the extent of personality protection from the Netherlands of a very famous soccer player, where the court recognized a quite extensive personality rights protection. This is a question that is becoming of growing importance as the identity of certain persons become more and more valuable. And we are seeing more and more case law that is developing this concept about the personality protection. As for the AI related question, I think it might be touched upon by subsequent speakers, and it so many implications by AI questions. But I would say in general, the question of identity protection is becoming increasingly important, and that I can then actually use my last slide, because when we have cases, the right holder will usually rely on as many rights as possible, and you will add in the end also the personality protection and the unfair marketing and passing off protections. So it's very important to put everything into the case at the same time, including the personality right. But lots of national differences applies to how the courts will look at personality right protection.
Thank you, thank you. There's just a very quick question from Hanna Stakeva about the Trunky case, which she missed, which is whether it was a design or a copyright case.
That was purely a design case.
Right. And one last question, since we've got 1 minute left before we break, and further questions will be taken later from Petar Svetkovic, who says, this is about NFTs, which you mentioned earlier. Can you register a trademark on the NFT instead of at the IP office?
No, you cannot. And I think the whole point for NFTs, for domain names, is to have a protection in that field. Secure your normal registration procedures for the trademark, and then use it in the NFTs and the domain name space and all of that. But to have that protection going into these digital media, you need to still have the foundation that is in the normal registration system. So my short answer to that will be no. Make sure to have the full normal protection first.
Thank you so much, Erling. I'm sorry I stopped you early, but actually you've woven the rest of your slides into the answers. Excellent, excellent. There are still more questions. We'll try and deal with them later. We should, on time now, break. So now there is going to be a 15-minute coffee break, and we're going to start exactly on time at 11 Central European time in 15 minutes time with practical case studies. So please see you back here, all of you, in 15 minutes time for some practical case studies, but we'll break now for 15 minutes. Thank you. Hello, everybody. My computer clock now shows 10 past 11 Central European time, so we will begin again. And our next session, as I mentioned earlier, is practical case studies, your client as a claimant and your client as a defendant. And our speaker will be Maria del Mar Baldares del Barco, again from the observatory at the EUIPO. Maria has been working at the EUIPO for 12 years on convergence of EU practices in the academy and currently at the observatory, where she specializes in enforcement matters and IP awareness for SMEs. She's experienced in designing and delivering specialized IP training for small businesses, their advisors, as well as law enforcers. She studied law and specialized in IP and worked for almost a decade as a lawyer in IP matters for international clients. Maria, over to you, please.
Thank you, Jonathan. Good morning. And well, it's a great pleasure to be here today presenting the result of our work. Now, my presentation will be about a very practical subject matter, because we have been working to provide exactly this type of practical information for the members of the CCBE in general. So I will be basing my presentation on a document that is available online in all EU languages. And this document, you can download it in any of these languages that you need. And more information on that will be given later. However, just so that you know, the questions and the methodology that we have developed in order to better ask questions to your client is contained in this document. So I'm going to share the presentation now. Just one second. And
Nothing yet, Maria.
not yet? Okay,
No.
Sorry about that.
Don't worry.
And let's see now if this works. Okay, can you see now my screen?
Not yet, not yet. It's not engaging. Normally the sign comes up that it's about to be shared.
Okay. Just one second.
If you want us to show the slides from here, they're coming, Maria. Yes, you need to make them big, that's all.
Okay,
Full screen.
there we go. Is that visible now?
Yes, it is. Thank you.
Okay, thank you very much. Thank you very much. Okay, so as mentioned, this is going to be quite a practical, hopefully practical session for all of you. And we will be looking at two scenarios. First, if your client is the claimant, or second, if your client is actually the defendant. Now, if your client is the claimant, there are, the way that we have processed this, there are in general scenarios where this can take place. Once you are in each of the scenarios, there are some questions to ask the client, and we will do this using a practical case. And the same will be done if your client is a defendant. I hear that it's showing the notes, my presentation.
Yes, it is showing the notes. That is correct. If you
Okay,
can make it fully full screen, that would be better. I mean, the slide is perfectly visible, but the notes are showing, yes.
yes, just one second. I'm going to try again.
Okay.
Better.
Yes, there you go. Thank
Yes,
you.
it's working.
Yes, and the notes do not appear. Well done. Thank you.
Okay, excellent. Thank you very much. Good. So we will follow the same methodology with the client as a defendant. So let's start. There are three different scenarios that we have identified so far. The first one is when you the client comes and tells you, oh, okay, I suspect, or actually I know that somebody is using IP without the consent. And this is the most typical examples are, of course, products that are identical to yours that are on the market, or today, and this is where they mostly are, on the internet without your authorization. Another very typical example is when a former employee reveals confidential information, or even one of your business partners reveals confidential information. So this is a very typical scenario of IP infringement. Another one is when you believe that actually somebody intends to register or has registered an intellectual property right conflicting with yours. Let's imagine a trademark, a design being filed in front of an intellectual property office that is identical or even very similar to yours. So taking advantage of course, all the effort that has been invested in so far, or the reputation. And a third scenario, and this one is very important, and it's becoming more and more important in practice, is when you see a high risk that your IP will be infringed. This is because sometimes you have seen throughout, or the client has seen throughout their experience, throughout their work, that actually there is a tendency to copy your or their intellectual property. And this is also something that happens a lot in trade fairs. And so for this reason, well, we're going to start looking into these cases in a practical way. Just 1 second, I'm getting a message. Okay. We're going to look for, right now at a practical case. It's an infringement of intellectual property, and in this case, it is actually confidential information, or what is also called trade secrets. Now, confidential information, in this case, it is a judgment of the Business Court of Antwerp from 2019 of a recycling company, and it governs recycling. And it was a small business, actually, so this can happen at any size of the company. This was, in this case, a small business, and the defendant was one of their service providers, so a consultant who was helping them to work on their everyday activities. And in this case, it was they were creating some production lines for the production of recycled plastics, and the consultant was helping them in this information. However, they detected that the consultant was copying files containing confidential information on a USB stick and actually using them for their new client. So we will have a look at this case. Now, as we mentioned so far, intellectual property this is one example of intellectual property, business information, which is relevant and which in this case should have been kept confidential. So let's move on and see how this works. As I mentioned before, we have defined a methodology to help you, to assist the generalist lawyer when a client comes with an issue that might be an IP infringement. So if we look at these 6 main questions to ask to your client, some of them I will actually refer to the case at hand so that we look at it in a practical way. Now, the first question was here, what are the infringing actions and how do you find out about them? Of course, so if in this case, when the claimant was asked these questions, what had occurred was that the claimant had discovered that one of their technical service providers was working for one of their competitors. And not only that, but they realized that they had started copying files and putting them on a USB stick and allegedly passing on this information to the competitor. So another question that is important is the infringement taking place online or offline? Well, in this case, it does not have to do with online. It was offline. However, just bear in mind what I said before, that today, most of the infringement, a lot of it is taking place online in social media or using the internet just as a means to infringe intellectual property. Now, the next question is, do you have any proof that can be used in legal proceedings? Any type of proof, for example, any evidence or even an affidavit, so first-hand evidence or from other parties. Now, in this particular case, the claimant had hired a forensic IT specialist, an investigation firm, with which they were able to show that the information about their production lines had actually been passed to the competitor. And there was also an interesting proof that was necessary in these proceedings, and it was what was the relationship between the service provider and actually the company, the claimant. They did not have a contract in place. However, for many years, they had been the defendant had been issuing invoices to the company and they had been paid. And this was sufficient evidence to prove that there was a contractual relationship between them. So it's always very important when you're analyzing a particular case of intellectual property to have a look at all the proof that is available so that you can present it in any type of legal proceedings. Now, it was also asked if they owned or licensed any intellectual property rights. In this case, we are talking about, oh, excuse me. I don't know why the presentation. So, sorry, something has happened to the PowerPoint. Okay. Here we are. So if they owned or licensed any registered intellectual property rights, or in this case, we were talking about trade secrets. And when looking into the trade secrets, we have seen that the trade secret that this company owned was actually optimized production lines, not just standard machines, but actually something very, very specific. This information was not available to the general public, and a lot of data, as we were able to listen to before, a lot of data had been copied in a very short period of time to a USB stick and passed on to the competitor. So they did own trade secrets, and these trade secrets were being actually infringed. So what about any steps to enforce the rights or stop the infringers? Now, in the case of trade secrets, and this is something very important because as mentioned before, trade secrets is actually one of the most used intellectual property rights of small businesses. So it's quite possible that any lawyer will at some point be faced in a situation where the client has trade secrets. Now, had any steps been taken to enforce the rights and stop the infringer? Well, in the case of these trade secrets, it was proven that the claimant had invested in data security. So not everybody had access to all of the information. Now, this is very important in trade secrets, but in general, in anything where there is where it is important to keep some secrecy, and also in patents, especially at the beginning, before these patents are filed for protection. And different people had different rights to information. So this also shows some diligence. Also, several times the information stated that it should not be disseminated. Now, this is very, very important to mark always that the documents expressing if these documents can be disseminated, or if they are confidential, or if they should be kept in some way secret. Very important. It was also determined by the court that in the professional circles of research and development, it is very common not to disclose the information obtained and the knowledge acquired. So this had been also something that was decided. So what is necessary to advise your client if your client is a claimant? Well, it is very important to take action against the infringer, because the problems are probably, as we all know, not going to stop on their own, right? And depending on the type of intellectual property, it is very important to consider hiring a lawyer specialized in intellectual property who could assist with, depending on the case at hand, the most important actions to take afterwards. Now, it is very common, for example, you as a lawyer can help with a cease and desist letters. This is something very, very common, or asking for notice and takedown actions. Takedown actions meaning when products are being infringed on the internet, you ask the companies to take down the advertisings, for instance. You can also, if applicable, think about negotiation of a settlement as a way of finishing the dispute. It's possible to take administrative proceedings, for instance, in case you have to go, for example, to an intellectual property office, national or regional one, or monitoring services as well. Now, if these steps were not sufficient, and then it might be necessary to advise your client to consult a lawyer who is specialized in IP on civil proceedings. Okay, so civil proceedings is the next step if reaching an agreement, amicable or in front of an office, or a settlement is not sufficient. Now, there are also cases where things get a little bit more complex, and counterfeiting and piracy activities are involved. Now, counterfeiting and piracy is, of course, a more serious type of infringement, and you might want to start then with the client criminal and or administrative proceedings, for instance, as mentioned by Erling, stopping goods at the border and not allowing them to enter the market because they are counterfeit, for instance. So law enforcement, customs and police, and of course, you might want to do applications for actions through EUIPO. In the case that we were talking to before about the production lines of recycled plastic, so in this case, these injunctive measures were requested before the court, and the court validated the extrajudicial dissolution of the contract, and it was ordered to cease and desist from using and disclosing the copied files, and it was ordered to pay damages and, of course, legal costs. So here we can see how the claimant was able to succeed in this case. Now, if we continue and we see the other side of the coin, so your client as a defendant. Now, it is different when your client comes and tells you, okay, first scenario here, I have been accused of infringing the intellectual property of another person or company. Now, this can be quite intimidating, no, for a client. If your client has received a letter from a lawyer or from a court when it's stating that they are in conflict with another company's intellectual property in general, a trademark, a patent, a copyright. That's one example, which happens quite frequently. Another scenario is they receive actually a notice of opposition, a cancellation, or a similar procedure against your client's intellectual property application. So your client receives the opposition and somebody claims that actually they own an earlier sign or a similar sign to theirs. And another scenario would be, once again, the issue of the risk. Now, a client could come, and I had it a couple of times when they came with a registration, and then they tell you, but you know, I was inspired by products that are already on the market. This is, how do you see this? Where is the border? Because there are, for example, designs that become fashionable, colors that become fashionable, and inspiration is something used a lot. Another very usual activity that is taking place today, and is especially on social media, is when publicly available content is used on social media. So a picture that has become a trending topic is reused, for example, on somebody's social media, photographs of others, etc., etc. Music, using music to advertise part of your activities. So all of these activities might be a risk, and it would need some analysis. Now, for the case at hand, because we have not, what we tried among our colleagues was to distribute the different types of intellectual property rights so that we could also, in a practical way, look into all of them. Now, in this case, we're going to be looking at a case of infringement of a patent. This is a case from Düsseldorf, Landgericht Düsseldorf, a case from 2019. And here you can see a picture taken from a trade fair. So it's a very, very practical and very real example. The claimant owned a European patent granted for Germany for a heat insulation component used for buildings. Now, the defendant was in a trade fair actually offering or exhibiting a prototype of a heat insulation component in Munich in January 2019, and announced on its website its launch for later on that year, also 2019. Now, the petitioner filed a request for preliminary injunction for information about and delivery of the infringing products based on a risk of a first-time patent infringement. So we will go into more detail, but what you can see here in the picture is actually a photograph taken at the trade fair. So we'll look into more details now as I explain the different scenarios. So the 6 main questions to pose to the client that we found or that we consider could be useful. First of all, in your opinion, are the allegations received reasonable, and were the proper grounds stated? So this moment, when the client arrives with a situation that is for sure creating a lot of discontent, is okay. Let's look at these allegations and please tell me if these are reasonable. Well, you will see later as continue explaining this case that the allegations were quite reasonable. They were alleging a risk of a first-time infringement, and this has to be proven by the right holder in this specific case in Germany. Now, in this case, the exhibition of a prototype at the trade fair and the announcement of the market launch was the beginning. And the court considered that in this case, it was quite obvious that there was a very, very high risk of this infringement taking place, quite imminently as well. So the next question is, are the intellectual property rights that you are potentially infringing actually protected? And how are these rights used in the market? It is very important to analyze when you are being accused of infringing an intellectual property right that the intellectual property right is, of course, valid. Now, in the case of patents, it was mentioned before, it's 20 years. Now, in this case, it was a patented invention. And not only that, but furthermore, it had been confirmed by the European Patent Office and by the Federal Patent Court. So the validity of the patent was very, very clear, was clearly there. And the possibility of infringing again was also there due to the fact that it had been not only presented in a trade fair, but also announced on the website. Do you own or license IP on the subject matter? And do you openly claim and use them for your business? And since when? Now, we do not see evidence that the defendant owned intellectual property right on this specific subject matter. Now, both companies were competitors on the market, and it was important to understand that they were both working on the same field. It gives some idea of how the factual situation actually is. Now, what actions have you taken until now to avoid infringing others, including the IP in question? Now, from this case, we do not see anything of, for example, going into monitoring services or taking actions to avoid infringing others. However, this is, as you will see very soon, I would like to take a couple of seconds to talk about how to take actions to avoid infringing others, especially for small businesses. This might be devastating if, due to lack of care or ignorance, you start infringing the rights of others. A company infringes the rights of others. The consequences might be very, very serious. So I will go into more detail that later. Do you use or have trade secrets and domain names covering the subject matter? Well, in this case, it was not the case. However, it is always important when you are analyzing a situation to see what both parties own and if there might be overlaps. So this we consider an important question to ask to understand the factual situation. And are the intellectual property rights of other measures older than the IP of the claimant? Well, in this case, this patent that was filed was actually filed on 4th of January 2002. And they claimed a German priority from January 2001. So this was 2019. So the earlier right, the patent, as we saw, is in force still. So the situation, well, was quite clear for this patent infringement. Now, if your client is a defendant, what type of advice would be useful? First of all, whenever there is a case of potentially infringing others, it is very important to immediately stop the allegedly infringing activities and analyze the situation very, very carefully. Because infringement, as it goes on, if you stop, you put a standstill to the damages and to the whatever is going on. So first stop, and then, of course, consider hiring a specialist. Now, what type of activities? Well, once again, it's similar to what we mentioned before, responding to cease and desist letter or other allegations from third parties, negotiating settlements, or perhaps going into mediation or arbitration. So trying to find some solution between the parties. Now you can also, of course, go to the administrative proceedings before the offices. So you might want to, cancel the earlier rights, file an opposition, etc., if necessary, or obtain defense if you have an opposition or a cancellation, etc. And of course, the same goes for civil, administrative, or criminal law proceedings. And here's where I would like to take a moment to talk about making searches in intellectual property databases to avoid infringing the rights of others. Now, why is it so important to make searches? Well, because it is the client who knows best where they are active in the market. And it is the client who knows best how to find out if he's being infringed. Now, in this case, for instance, you can see that they were both competitors in the market. And actually, the client, the defendant was announcing on the internet some products that were infringing the patent, insulation for construction, but also they were going to a fair, and it is the parties, the people involved in the business that know where are the fairs, where is the advertising taking place. Now, searches can be of a very different nature. Now, if you are, for example, if you have a trademark, you will want to find out in trademark registered. So Trademark View, for instance, it's a database, TMView, containing many millions of registrations, and you can make a search to see if when you want to file a trademark, you are not infringing already existing trademarks because they are similar or different. In the case of patents, it is more complicated. A patent search requires a very thorough technical analysis of the patent claims and to understand which claims could be conflicting with those. However, if a company is going into this type of investment of a patent, it is very important and very diligent to obtain a freedom to operate report from an expert. So we advise always the clients to make searches to avoid infringing the rights of others. Because, for instance, in this case, well, in the case of this company that went to the trade fair to announce this insulation material, the defendants were ordered to cease and desist in presenting this prototype. They had to pay a fine. They were of up to 250,000 euros. If the fine is irrecoverable, well, it would be replaced with an administrative detention of up to 6 months. And then, of course, they had to secure it was requested to the destruction of all these materials that were infringing the patent. And the claimant, to secure this, had to deposit 300,000 euros. So for a small business, we are talking of some figures that could be quite difficult. So as mentioned, all of our methodology, for going into the steps of how to help a client that comes as a claimant or as a defendant with possible IP infringement, we have developed a short methodology, some questions and some steps, and they're all available in a document that you can download and that will be talked about later in the by my colleague. So I will stop sharing now.
Well, I'm very pleased that you have ended a couple of minutes early because there are really a lot of questions. I won't spend any time. You dealt with IP and trade secrets, which was an early question, so I don't think you need to say more about that. But you're just going back to what you said about databases. Somebody asks, do IP lawyers only have access to the public IP databases offered by EUIPO and EUIPO, or are there any others?
If only IP lawyers, no, any lawyer has an access. So these databases are free of charge and they are available always on our website.
No, I think, sorry, the only is my fault, but it's also the questioner's fault. Doesn't apply to only IP lawyers. It applies to only databases. Are there other databases other than EUIPO and EUIPO databases?
Well, the national offices also have their databases, but mostly they are linked. Because at the end, at least with the EU offices, there are agreements with the EUIPO. So at the end, it is the same database, but it is a very complete amount. Now, There are other databases, for example, the Plant Variety Office, if you're dealing with that type of issue, has a database also on plant varieties. Geographical indications, you might also want to look in there if there are some other earlier rights. So intellectual property covers so many rights that depending on the type of right that you are looking at, you will have to look for the institution that contains the databases. We have some links to that in our two-pager that can be downloaded. So the different in the different types of IP rights, and then. For patents, of course, the European Patent Office has their databases for making trademark patent searches. And then there are some national offices that offer the possibility to make the searches for you as well. So depending on the complexity of which is the earlier right that you are looking into, you will want to look into different databases.
Thank you. Very helpful and full. And I see the EUIPO database link has been put up. You referred to a two-pager, and people have been asking about the paper to which you referred. Does that mean the brochure?
That means the brochure, exactly.
Okay, well, there's been a link put up to that on the chat already. Thank you. Claudio Ferraru says, you've spoken a lot, and other speakers have spoken a lot about goods coming into the EU and breach and what you can do. But what about if the good is going in the other direction, from the EU country to a non-EU country? Can you still take infringement proceedings?
So, well, there are leaving the EU there are different scenarios. No, I believe somebody asked a little bit earlier also about goods in transit, for instance. No, so goods in transit would be goods protected by, for example, trademark rights coming from outside of the EU, entering the EU, but on transit, leaving again the EU for a third country. Now, with the trademark reform, there has also been granted protection for goods in transit. It is quite long. We could spend another hour here talking about goods in transit, but yes, you can stop goods in transit in the EU. And important to remember that what was mentioned in the beginning, the territoriality of the rights. So when goods are stopped, it is important to know if they are registered, if they are valid, and if they are also valid in that third country where the goods are going. So all of these considerations have to be taken into account if you would like to ask for means of protection or stopping goods.
Right. You mentioned earlier about how important it was in certain circumstances that you mark confidential to show what you want to mark and what you don't. But Maria Angel says, how do you prove the infringement is actual where the companies mark all their emails and documents as confidential? How can you distinguish?
Yes, of course. I mean, there also has to, well, there has to be some common sense. No, of course. It is, for example, if we're talking about trade secrets, no, there are kind of three elements. The information must be secret in itself, meaning it is not known to the general public. It is not something out there that is known to everybody. It should have economic value, and the holder must show reasonable steps to keep the information secret. So basically, these are like the three requirements. No, and among the reasonable steps, this is all a question of proving the factual circumstances at hand. And one case was here proving that the information was confidential, writing on the document that it is confidential. But if we remember correctly, that was not the only reasoning. They also mentioned, for example, in research and development, it is common practice to not openly tell what you have obtained in the framework of your contract, no, or of your relation with your client. And they also went into the topic of good faith as well, which was also mentioned before. There was also a question about good faith. Well, in this case of the trade secrets, it was discussed the fact that if you are a consultant to a company, it is part of the expected good faith of commercial practices that you do not go to the competitor and give them the information that you obtained one client. So all of the things together are there. Who has access to the information is really very, very important when there is a situation of intellectual property management. So IP management is a type of advice that can be given to any company when they look at all the intangibles they have and they give them the best measures of how to protect them. That would be like a kind of IP management. And something that is very, very important is who has access to which documents and how are these labeled, because it is very important to keep the information in the right hands.
Thank you, thank you. We need to stop because I see Benjamin's there and we need to go on to his... I would just want to say to the people asking questions, there are a number of open questions which haven't been dealt with. They're all very excellent questions. Thank you. Keep on asking. We'll try and deal with as many as we can. You're not forgotten, questioners. Thank you very much indeed, Maria. Thank you so much. We move on to our next session, and that is called IP and New Technologies. Some of the questions relate to that which I haven't dealt with yet. Practical tips to advise clients. Our speaker is Benjamin Winsner, who also works at the observatory at the EUIPO. He's a Swedish lawyer who's worked there since 2016. He's worked with intellectual property since 2008, both privately and in government institutions. He focuses on new technology and the misuse of different intermediary services for IP infringing purposes. Benjamin, over to you.
Thank you, Jonathan, and thank you for giving us the opportunity to present our work here. I'm going to share my screen in the presentation. Let me see. I think
Nothing
is
yet.
Is this the one?
It's coming. Yes, it's there. Thank you.
Okay, perfect. Thank you. So we've heard all morning the importance of IP and what IP can do for your clients and the business. But as an effect of that, it is also important to kind of monitor your rights. Yeah? So similar to you investing in shares or a company, you need to monitor the performance of that company, because otherwise you run the risk of having your investment kind of fail. And the same applies for intellectual property. And I think a couple of colleagues have mentioned that. I mean, the development of the internet and new technologies have just kind of exploded. And whilst it was quite easy to maybe monitor your rights 20 years ago, today it's much more difficult because it can easily be accessed and misused online in different channels. So today, I'm just going to go through briefly a couple of them and explain what you can do. So first of all, the use of someone's IP in social media. So I go back to kind of the search. So we heard Plamen and Erling discuss, okay, so who can action a right? So normally you don't have a third party who's good enough to say, look, I want to take action on the right holder's behalf. So normally it is the right holder. So, and how do you make sure that people are not using your IP? And there are several existing monitoring services out there. If you don't provide it yourself as a law firm or an expert, you can always hire specific companies that has specialized in monitoring certain use online. And that can be for IP infringing purposes, but it can also be, depending on how big of your company you have, how many brands you have, it could also be used as a compliance tool, so to make sure that your affiliates use your brand in the right way. You can use certain technologies to facilitate this search. So normally you can watermark certain materials. So it is easier for these monitoring services to detect that. And I think it's been mentioned previously, but we have an anti-counterfeiting technology guide. I'm not sure if the link is up. It's definitely a link in the leaflet, but there you have certain technologies that can be used for online content to make sure that it's easier to detect them. In terms of social media, I would say that it's easy to turn to the specific social media themselves. So, for example, Facebook have a Right Manager program, which allows you to upload your content and ask them to do this monitoring for you. Similar, YouTube have a Content ID program whereby they monitor their channels for content that you have uploaded and verified as your own, and they will notify that if they see a misuse. Once this has been detected and you have the results, you obviously need to evaluate the issue. So if it's a proper infringement, fair enough. When it comes to social media, you also have these type of freedom of speech. We heard from Erling, a parody case or satire, which might not necessarily, might use your brand or your IP right, but it doesn't necessarily mean that it's an IP infringement that the platform will take action on. So it's very important to kind of determine what type of infringement or what type of use that is being done online. And then you have different type of actions. As I said, the platform can monitor content for you. They will let you know, and then it is up to you as a representative or an IP owner to take action. So one could be through these platforms. So they normally have a notice and take down action, and you submit a complaint to them, you provide evidence, and they will reach out to the account holder. If that seems to be unsuccessful, maybe because they don't regard it as an infringement, and in fact, it might not be an infringement. It could be something, if it's a public person, they can be derogatory or defamation, and then you have to go against the account holder itself. Then if that doesn't help, then obviously, as Maria has explained, there's a couple of offline actions you can take as well. In this section, I also want to mention a new regulation that's come into effect called the Digital Service Act. Even if these accounts or platforms have notice and take down mechanism in place today, they definitely have to do it now because the digital or the DSA has made this an obligatory condition for them. So they have to set up a notice and take down action. Also, what could be interesting is that they have an obligation to provide an alternative dispute resolution. So in case the parties doesn't agree, it's easier to do that rather than to go to court. If we look at the other side, if you have a client coming to you asking what they can do, I think, as Maria has pointed out, it's very important to do your due diligence before any type of publication. If we then move on to e-commerce marketplaces, and here it's the same kind of principle. You need to find out what type of infringement is out there so you can use existing monitoring services. You need to also here evaluate the type of issue. So normally you have someone selling your goods that are infringing or counterfeits, but you can also discover kind of parallel import and those type of issues. And depending on what type of issue you have, there's a different type of actions needed to be taken. So the marketplace also have notification systems in place, and certain big ones have IP protection programs, which is similar to the Content ID and the Right Manager accounts that we see on social media. That is that they kind of not protect your right for you, but they will do searches themselves based on the information that you have provided to them. And they can then take down certain listings without you even having to point it out for them. So yeah, and not all marketplaces have it, but certain do. And EUIPO, we actually have a repository of, I think it's 14 odd marketplaces, whereby we have collected all links to relevant notification system, but also IP protection programs when they have them. And the link is in the presentation, so you can go and have a look later on. If everything else fails, as with social media, there is also options, obviously, to go and address the account holder themselves. But normally, e-commerce marketplaces are quite good in replying. And again, the DSA, which also apply to e-commerce marketplaces, as well as social media social media outlets, they now have an obligation to have this notice and takedown mechanism in place. In addition, they also have an obligation to respond to these notices quite quickly. So whilst previously that might not have been the case, they might have done it anyway, but today they actually have an obligation to do so. If we then go to app and app stores, and like with all these online intermediaries, you need to search for any type of infringement or how your brand is being used. When it comes to apps and app stores, it's a bit more difficult given the nature of apps and app stores. So when you search on the web, so in social media and on e-commerce platforms, everything is out in the open. So these programs, they crawl the internet to search for listings or posts or any other text that you have predefined. When it comes to apps, if it's not from the App Store, if it's not on the face value of the app, i.e. the app is using your logo or the brand is used in metadata, i.e. the description of the app or something similar, then it's difficult to find out if the app is infringing on your right or not. What normally happens then that you have to download the app, you need to go into the app and see what the functionalities of the app are. So it could be disguised as a game, but if you then click further on within the app, it actually takes you to different websites where you can find counterfeits or illegal content such as streaming facilities and stuff like that. So it's a bit more complicated to monitor these type of services. So different type of actions. The app stores also have a notification system and other tools that they use to make sure that they don't publish any type of apps that are infringing or illicit in any other way. What they normally do is that they receive your notification, they do contact the developer, and normally they ask the right holder and the developer to come to a conclusion. If that is not possible, then the App Store will evaluate and take action that they deem necessary. What is important to know, and it's just a side caveat here, is once an app gets deleted from the store, that doesn't necessarily mean that the problem is away. And if the app has been downloaded, the app will still remain sometimes on the device it's been downloaded to. And depending on the issue, if the developer remedies that, potentially the app can be uploaded again. But well, if it's a clear-cut IP infringement case, that would probably not happen. Then, if we talk about what type of IP you have connected to an app, we've heard it all morning. There's different type of IPs, and an app similar to many other products can have various type of IP connected to it. So it could be a trademark, the name of the app. It could be design, i.e. the app face, so to speak. You have copyright to the code, potentially patents, depending on jurisdictions. So there's a lot of IP connected to these apps. And what you should keep in mind, and I'm not going to go into the details of it, but depending on how the app has been developed, you might want to regulate the IP through contracts or license agreements, because internal development, normally the employer through the employee contract will retain the IP, but if you use external consultants, you might want to regulate that. So you receive the IP rather than the author of that. Then you have, if you, depending on if you develop apps for, say, for example, the iOS systems or Apple's, you might have to use some specific software that you license from Apple to be able to build these type of apps. And then finally, we've heard it. I saw some questions. AI. This is a very hot topic at the moment, and obviously this part of technology have just boomed, well, the last year, so to speak. So you have these type of AI solutions that use public accessible material to create their own content. So, and they are allowed to do this through the copyright in Digital Single Market Direct. So there's a text and data mining exception, which states that if you have lawfully accessed works or other subject matter, then you can use it for data mining purposes. However, in Article 4.3, there is a possibility for the author to opt out. So basically saying, I don't want you to use my material for these type of solutions. And there's various ways to do this. You can write it plain next to the content that you wish to exclude. You can have it in the license agreements. You can have the terms and conditions of the website specifying this. But you can also use technical solutions such as robot.txt, which is a code that you embed into your website that kind of tells these Gen AI solutions that I don't want you to use the material that can be found on this website to kind of be used in your solution. There is a new AI Act coming soon, we think, before the summer. I think we'll see if that happens, but they are fairly advanced. Depending on what's happening with the election and everything, it might be delayed, but our hopes are that it will come before the summer, but it won't take effect until 18 months after, I believe. And the main part of this AI Act, I should say, is that they still have this opt-out. Today, a right holder probably need to kind of prompt or make the owners of these AI models aware that they have opted out. Whilst after the new AI Act comes into force, it will be actually on the owner of this system to research this. And I can see you, Jonathan. I will wrap up. When it comes to work produced by Gen AI, it's very much unclear, but we've heard this morning that it requires some type of human interaction. And there's a lot of case law coming out. I think the main part is that should we see AI as a tool, i.e. like a camera, or is the AI creating this themselves? At the moment, if I were a betting man, well, at the moment I can say that I don't think any court would say that content that has been produced by an AI solution has copyright. But depending on the evolution, that might change in the future.
Thank you. You were clever to put AI at the end because it was so important. I didn't interrupt you early. Let's just take one question about it. Is a picture generated with AI assistance protected under any intellectual property rights? Would it suffice to establish the creative input of a human author by documenting every step and recording all the key words used in generating the picture?
Yeah, this is what I mentioned in the end here. Today, I don't think so. However, we saw the same. So when the first camera came, it was also it's a tool. I mean, you take a picture of something that existing already. So it depends. Today, I wouldn't say so, but the more prompt you use, the more kind of the tool is dependent on your input to create these words. Then obviously one could say that it's actually work stemming from yourself and not the tool itself. So, but it's not that clear today, to be honest.
Very quick question, Theodore Kazantsev. If the app is already downloaded, can't it simply be disabled, or must we take additional action so that the app is disabled on the devices on which it's been downloaded onto?
Yeah, I mean, today, no, it depends also. I think it depends on what type of app that we're talking about. Sometimes a device manufacturer that controls their own store, they might be able to go into the device and disable the app itself. But that requires quite a lot. And even if I think IP infringements are very important, there are other issues that are much more important, both to the legislator and to the app stores. So I think when they go in and kind of, I don't think they delete, but they can certainly send out warnings. But that is mainly due to kind of personal security and theft of information when they do that type of thing.
Thank you thank you, Benjamin. We must move on. Thank you very much. Very interesting. And let's move on, because then our next speaker, who is Yasin Guyarov, is going to speak about something which has been mentioned repeatedly during this seminar, and many questions about it as well, which is to do with the brochure IP enforcement for generalist lawyers in the EU. So you'll find out more about that. Yasin is a seconded national expert from Bulgaria, part of the EUIPO's Observatory Outreach and Knowledge of IP service. He's been working on various support initiatives for SMEs and the implementation of the MOU with the CCBE, which has led to today's webinar. Yasin, over to you.
Thank you very much, Jonathan, for the presentation. I will just share my screen and please confirm if you can see it correctly.
Yes, we can.
Perfect. So indeed, I will present the brochure, and at the end of the presentation, you also see a QR code which you can use for downloading it, but also the link has been shared quite a few times already in the chat. So hopefully each one of the participants gets to have the brochure, because it was created especially for all of them and in mind in view of this webinar today. As it was also mentioned in the very beginning, this is one of the first deliverables of the MOU, the Memorandum of Understanding between the EUIPO and the CCBE. And it was specifically created for generalist lawyers, so not for IP lawyers, but really giving the generalist lawyers the initial information they need in order to give guidance to their clients. And by clients, we mean specifically in this case small and medium enterprises, because we have been seeing that they are the ones struggling quite a bit when it comes to IP infringements. So we are trying with different initiatives of our office to help them as much as we can. And of course, lawyers are one of the first instances where these small companies go to. Something very important and is that we managed to have this brochure, and I hope that all of you will have it on your desks at some point. We try to have it very concise, very brief. So it's only, we call it a 2-pager, but we managed to have it in all EU languages. And here we would also like to thank to all the lawyers that gave comments and insights to the different language versions. So not only you have them in the different languages, but in some cases also thanks to the comments of representatives of the national bars, we managed to adapt also a little bit the content depending on the member state. So we hope that it's a useful document for you. Just briefly mentioning the different parts of the documents. So in the beginning, we start with a more general overview why IP enforcement is important. So mentioning how companies can sell, license, and franchise their IP. Basically, the attractiveness that it has for especially for small companies. And then we proceed with defining IP infringement, counterfeiting, and piracy, all the things that were already mentioned by my colleagues earlier. A very useful, I believe, page is the one where we have listed all the different types of registered IP rights, or let's say the main ones, as well as the different IP protection measures, such as trade secrets, domain names. So this is a page where you can also see how the various IP measures can be protected, for how long and where to go to. So whether it would be a national IP office, the EUIPO, the European Patent Office, or another authority. So you have all of this mentioned on the second page of the brochure. And then a part which correlates very much to Maria Del Mar's presentation. So your client as a claimant and your client as a defendant. We have provided 3 different scenarios which apply in both situations, as well as the possible next steps, which were also quite in detail mentioned by Maria. So not going into these details at this stage. And finally, at the end of the document, you can see some quite general, but we still believe useful tips which relate to Benjamin's presentation. So tips to advise clients with who deal with new technologies, meaning social media, e-commerce platforms, mobile apps, and generative AI. And at the very end of the document, you have all the useful links that we collected. So of course, you have the EUIPO website, the CCBE website, and then some of the initiatives that were mentioned also throughout the presentation, such as the Intellectual Property Enforcement Portal, the Anti-Counterfeiting Technology Guide, our frequently asked questions on copyright, the EUIPO Mediation Center, and also we listed some other bodies and authorities in the field of IP. So the European Patent Office, the World Intellectual Property Organization, EURID, the Registry for Internet Domains .eu, and the Community Plan Variety Office, as well as all the national or regional of IP offices in the EU, which are, of course, our main partners, and it's very important to have those links as well. So as promised, here is the QR code, so you can easily download your language version. And in case there are any questions, please let me know.
Thank you so much, Yasin, and thank you for finishing a couple of minutes early. There are no specific questions about the brochure. There have been, but you have dealt with them and we have dealt with them. But I'm just going to go, if I may. So either you can answer this or Benjamin. It really arises out of Benjamin's, if he's still there, if you don't mind. So it's to do with apps, which he dealt with before. And somebody has said, often the developers of such apps are really scammers, and it's difficult to liaise directly with them because they're scammers, and therefore the processes in place to file IP infringement complaints are not adapted if the people are scammers. So I don't know whether either of you has any comments on that.
Yeah, no, I can take that as well. So true. That is certainly true. I think the app stores are doing quite a good job of trying to mitigate that type of behavior, and certainly the bigger ones have very robust kind of notice and take down or notice and action mechanism put in place. The DSA will certainly apply to some of these app stores as well. So what I mentioned previously, that there's now an obligation to have these type of mechanism in place, certainly applies to them as well. Then you're right, smaller app stores that might not be as I don't know, I don't want to say stand-up citizens, but might not care as much. That's certainly still an issue. Yeah, you're right.
Fine, very good, very good. Yasin, your presentation was so perfect, there are no questions. And so 1 minute early, which is absolutely fine. We will move on to our last session, which is closing remarks and next steps. And our speaker is Anastasia Leonardi, who is a lawyer from Sol Montagnola law firm in Barcelona and Spain, and she's been with the firm since 2017. She has a master's degree in ICT, social media, and intellectual property from ESADE, the Universidad Ramon in Barcelona. She graduated in law from the University of Perugia in Italy in 2009, and she successfully passed the Italian exam to access the legal profession, meaning she's got a double degree, which allows her to practice both in Spain and in Italy. So very good. Anastasia, over to you for the closing remarks and next steps.
Jonathan, thank you very much for the amazing presentation. It's a pleasure to speak to all of you. I want to thank you, of course, European Lawyer Foundation, CCBE, and European Union Intellectual Property Office, and all my colleagues that they have already spoken. And what else? It's difficult to do the closing remarks after all this valuable information. However, I will try to do my best. So I think always is good to, sorry, I need to share my PowerPoint first of all.
Yes.
Yes. I will do it. Compartir.
Yeah, it's there. You need to make it full screen,
Yes.
and then it's perfect,
Yes.
Anastasia.
Yes.
Yeah,
Now,
that's
yes.
it. Yes, thank you.
Thank you very much. So let's go. My PowerPoint is simple, let's say, but wants to refresh some basic ideas about IP law, some what IP lawyers means, what are our challenges, and of course, I mention specific challenges and opportunities regarding the new technologies. So let's do it. First of all, when we speak about intellectual property, the first step is to identify which kind of rights we have and to protect them. So as it has been already mentioned, there are two parts, we can say. The industrial property in strict sense that include trademarks, design, patents, denomination of origin, and copyright, referring to artistic, scientific, musical, and literary artworks. I think for everybody is clear that is indisputable that intellectual property rights are fundamental for innovation, creativity, and economic growing. Another point to take into account is a regulatory issue. The regulatory issue, because when we are IP lawyers, we need to know and to understand that there are many levels of law, that is national law, European Union regulation, and international treaty. Although there is a high level of harmonization, it must be clear that the violation, for example, as it has been already mentioned, remain territorial, subject to the national law of each member state. IP, that this is the part that I like most, is a transversal subject. So it means that for us as a lawyer is like challenging because we have to know civil, administrative, and criminal law. And I think this is something very important because we ask to know a bit of everything in order to advise our clients. And another part that I think is interesting and is following with the concept of a transversal subject of intellectual property law is the fact that under certain circumstances, the right can be accumulated. For example, the characters of a comic, for example, or simply, like I mentioned in my slide, I include this photo of a very famous scooter that is Vespa from Piaggio, and is a great example of accumulation of exclusive rights. They include design, include a three-dimensional trademark and copyright because it's a iconic scooter. And I think it's very interesting to know how to advise our clients regarding this aspect. So let's move on. How, as IP lawyers, how we can add value, no, in this field, and how we can help our clients. I think there are a few things to take into account. First of all, to educate and make our clients aware about intellectual property, explain deeply what it consists, and it doesn't matter if it's a growing company or a startup growing company or a mature business, to make these clients sensitive about IP and the importance of IP. So the next step is like to help our clients to innovate and create and protect their assets. And not always is possible for our clients, for the company to create or to innovate. So in this case, is especially relevant to do background searches and to help them to make sure that the material that they are using, it's a material that is in public domain, or if it's not in public domain, they have to obtain authorization or licensing from third parties. And as a consequence of this, to help them create, to help our clients to create, for example, internal procedures to handle both their own intellectual property rights, or handle the licenses and the authorization that they have got, for example, from third parties. So after said that, in this general scenario, of course, we are facing as a lawyer challenges and opportunities, and I'm mentioning in my slide that we pass from machine learning to AI, generative AI, blockchain as a technology, NFTs, and of course, we will see more technology coming out, and this is a scenario that produce challenges, of course, and these challenges can be precisely the emerging technologies. These emerging technologies ask us as a lawyer to be updated with the developments and implications that may arise because of them. And I'm thinking about, for example, the use of ChatGPT, the way it collects data, the debate that it can vulnerate rights that belong to creators, taking into account that it works on contents that have been existing previously. This is emerging technology, for example, or the legal complexity. The legal complexity is because in this scenario, it's clear that to apply the traditional legal principle is not so easy. So we have to be especially careful, and especially when in the field that we are treating, there is no regulation. My colleague has mentioned the AI Act, for example, is something very new. We need to study it, despite the fact that is a framework regulation that which purpose is like to put EU as a leader in artificial intelligence, and also to establish certain principle of transparency, no discrimination, and etc. regarding the use of artificial intelligence.
Anastasia, sorry, I need to stop you because we always try to stop exactly on time because
Okay.
people have other engagements, and we've got about 30 seconds left. So, I mean, your slides will be put on the website along
Okay.
with everybody else's slides. So I think that's the best that we can do at these days. I'm sorry to interrupt you
Don't
before
worry.
the end, but we've come right to the end of our seminar, our webinar. So I will stop it now, just because it's now exactly 12:30. So just to thank all our speakers, Anastasia, you and all the others for your excellent presentations. Thank you so much. And in the chat, people have been saying what excellent presentations they are. Thank you to our speakers. I shall give, on behalf of all our many hundreds of participants, applause. And thank you also to the participants. Thank you. I apologize to those people who put excellent questions earlier on. We haven't been able to get to them. Very, very good questions. A very good session. Thank you very much to EUIPO. Thank you to the CCBE. And we hope to see you all again at one of our future webinars. So thank you for participating and goodbye.
Thank you.